And greetings, and welcome to Could Administrative Law Be Unconstitutional? And give me one moment, and let me just double check mic settings here. Make sure we get good audio going. No, okay, there we go. That should do that. And if everyone can hear me, if there's anyone in the chat that can just give me a thumbs up if everything sounds good, and we'll start moving along here. We're going to have Black's Law Dictionary with us, so we make sure that we leave no word behind. And I believe this is 7th edition. We'll find out in just a second here. Zoom in a little bit here so you can see a little bit better. There we go. Yes, 9th edition. So nice and new. This should work with anything that's addressed in this text we're about to read. And if not, then we'll make do with what definitions are provided within the text. So let's get right down to it. If everyone's here and you can hear me, yes, okay, let's do it. Oops, let's get back here to the book. All right. And I think I need to zoom in on this a bit. All right, so we're doing this article. It's by Richard Palmquist. It's Could Administrative Law Be Unconstitutional? So this isn't the voice of Mr. Palmquist. However, there's a lot of good material in here, references, and some rather good arguments that it would be, I think, very valuable for us to comprehend and to be able to articulate the essence of what Mr. Palmquist is trying to describe here, and to explain why our founding fathers may have actually felt this way as opposed to how some of the courts today feel about these administrative laws. So let's get right down to it. Could administrative law be unconstitutional? I am sure we won't find the United States government breaking its own laws. And that was by Richard Bach, Bridge Across Forever. Evidently fiction. At the risk of being accused of tilting at wooden mills, I will discuss here what seems to be a significant gap between the requirements of the U.S. Constitution contrasted with the reality in government today. Sanity is judged by how accurately we perceive reality. Is it insane to expect government agents and elected officials to understand and abide by that Constitution? Perhaps. Then again, it might not be that all people working in government are sane themselves if they show they cannot understand or be conformed to the procedure set down in that document. So let's look at a few things here. If they're asking if it's insane to expect government agents and elected officials to understand and abide by that Constitution, perhaps it is, because how accurately are we perceiving reality? Let's not fool ourselves. Then again, it might not be all that all people working in government are saying themselves if they show they cannot understand or be conformed to the procedure set down in that document. So do we get where we're getting at here? It might be that not all people working in government are saying themselves if they show they cannot understand or be conformed to the procedure set down in that document. To conform is an important word here. We want conformity with our procedures. That's why we have elected officials and government agents. They are to conform with the procedure set down in documents. So let's continue here. I want to be very clear as we start this what we're trying to build as far as our case here. To agree with what is written here could make you a cellmate of the writer in the looting bin of society. Or is there hope? Nobody would want to live in a city where streets were not paved, sewage ran in open troughs through town, or Old West six-gun law enforcement was necessary. We want an orderly society. Society depends upon the rules set down in administrative law to provide order and peace. Should the government in charge of providing order follow the procedures established by the Constitution to guide them in that job? Or should that government have absolute power? If the Constitution places power in the jury, should juries apply power, or should bureaucrats assume power over us? Now, that's an interesting argument. This is an argument where one might wonder about where the role of the juries here comes into this. So now we're starting to have a little bit of foreshadowing. Was there ever a wall? If so, what made it fall? The Constitution placed a wall of protection between government and the people. The U.S. Constitution, in Article 1, Section 9, is titled Limitations on Powers Granted to the United States. In paragraph 3, we read, "No bill of attainder shall be passed." If this provision is understood in its full meaning, what the founders seem to have done is to cause any law to be subject to review by we the people, putting a wall of protection between government and those it serves. At the Yorktown display in Williamsburg, Virginia, history opens our eyes to this issue. The museum plaque explains, April 1764, Parliament passes the Sugar Act to raise money from the colonies through import taxes. In response, Boston merchants refused to buy English luxury goods. Above this plaque is displayed a quotation from James Otis, Jr., a Boston lawyer, who wrote in The Rights of the Boston Colony, 1764, "Taxes are not to be laid on the people, but by their consent." Otis's declaration, steeped in his education in English law, expresses the conviction held by the Founding Fathers. They would only tolerate a new government, provided that government would be guaranteed to serve the people rather than demanding service from the people. If y'all are still there, if you could hit the like, leave a comment in the chat so I know we're still moving here through the metaverse and everyone can hear what I'm saying. Let's proceed. As Abraham Lincoln declared, "We, the people, are the rightful masters of Congress and the courts, not to overthrow the Constitution, but to overthrow men who pervert the Constitution." The power to exert the authority of the people rests in the juries. Grand juries for general oversight and ordinary juries to decide individual cases. That wall of jury protection was designed to prevent government from inflicting pain or punishment upon anyone without justifying the guilt of that person before a jury of peers. We call the United States the land of the free, and we value our individual liberty. There are times, though, when we feel the pain of government restrictions. We may wonder how free we really are. If we go back into history and look for the recipe for personal liberty, we may understand that we are not as free as our founding fathers intended. Their mixing bowl of freedom rejected king rule, divided government into three parts: and balanced the powers of those parts against each other, providing for elections, enabling grand juries to watch over government, making sure nobody was convicted of a crime without a trial by jury, and limiting the powers of government, allowing ultimate power to remain in the states and in the people. Most political historians would stop there, though they might agree that trials by jury offer a wall of protection against injustice. They ignore the prohibition against bills of attainder, or take a narrow view of the meaning of that term. Are we missing one of the ingredients of freedom because we do not understand bills of attainder? Has that misunderstanding removed the wall the founders intended to be our protection? So this is an important consideration right here. They might agree that trials by jury offer a wall of protection against injustice, right? We agree on that. However, they ignore the prohibition against bills of attainder, or take a very narrow view of the meaning of that term. So this is one of the ingredients of freedom, is what we're going to argue going forward here. And are we still, is the audio coming through, guys? Because I don't see anything in the comments. Okay, Chosen says something in the comments. Are you there? All right. I'll just assume we're still moving ahead here, and I'll continue. Perhaps you and I can bring a greater understanding of reality to the Alice in Wonderland queens of our day, who are intent on shouting, "Off with their heads!" Nobody will dispute that our founding fathers intended to limit the power of government, guaranteeing that individuals are free to go about their lives so long as they do not hurt other people. By outlawing bills of attainder, they gave juries the authority to have veto power over the common acts of government, to place a wall of protection between government agencies and the people. Through the years, though, brick by brick, that wall has been dismantled by the enactment of Bill of Attainder styled administrative laws. Today's government agencies, hang on one second here. Strange here, this doesn't seem to be working right now. Give me a second here, let me just refresh something here. Okay, there we go. All right, thanks, guys. Today's government agencies ignore or pierce the wall intended to protect us. So when I get some comments here, yeah, it seems like a fairy tale nowadays. Our government isn't for us. Yes, yes. Well, thank you for coming along for this. This is, to me, this is just a gem here, and I really want to share it with you all. It's been able to articulately express a lot of what I've been feeling as of late. So, today's government agencies ignore or pierce the wall intended to protect us. The courts have determined there is a wall of separation between church and state. Was a wall of greater importance designed by our founding fathers? Did they set up a wall between legislature and people? Did they not want laws to be imposed by an imperial majesty? King David was their example. They knew the story of David's thirst while fighting the Philistines. That's in 2 Samuel 23, 14-17 verses. They saw David reject his own bill of attainder. When King David's men learned he thirsted for water from a well in Bethlehem, occupied by the Philistines, 2 courageous men went behind enemy lines to get that water for their king, risking their lives. King David, though a man of war, knew it was wrong for a king to risk the shedding of blood in order to gain a personal advantage. He was not consistent in applying that value during his years on the throne, but he knew God's view of the issue. So, when David's warriors presented the water to David, despite his thirst, he poured the water on the ground, disdaining his own wish to attain it. Like King David, the founders wanted their new government to value human life above the proclamations of government. The U.S. Constitution has 2 purposes. 1, to structure government, and 2, to limit its power. You get that? 2 purposes. Structure government, limit its power once it's structured. The writers knew that any government was fully able to grasp power. Through Article 1, Section 8 of the U.S. Constitution grants certain powers to Congress. There was no reason to exert energy in granting power to the government. Instead, the founders listed limits to government power. That government was to be Republican, not a democracy. In a democracy, the majority can oppress the minority. The founders did not want that. Instead, they provided for the people to establish and maintain a government through representatives. By definition, a Republican form of government is limited by its enabling document, unlike freewheeling mob rule under democracy. Nevertheless, the fledgling government had difficulty dealing with apparent contradictions in the Constitution. The U.S. Constitution gives Congress the power to regulate commerce. While concentrating on that job, they seem to have neglected the limit to power that would have prevented that body from putting in place laws that would apply pains and penalties to individual people without first taking those individuals or groups before a jury to determine whether the pain or penalty should apply. So in these cases, sorry about this. Let me get this off the screen. This is one of the big problems here, is the pains and penalties being applied without a jury. Of course, they try to make it the easiest, most expedient and convenient way to solve an issue. And they'll play the fear of not complying too. However, as we see here, these are one of our fundamental rights that are granted through the U.S. Constitution's limitations on government. All right, let's proceed here. All right, chat's going really strange on my computer here, guys. Bear with me a second. I'm going to try and... I wonder why it wasn't updating. All right. There we go. Yeah, he understood God's order and hide from Saul. Yeah, God had his chance to cut us through it. Yeah, it didn't. Yeah, there's some more stories to that. Can't say King David was the most savory character. However, at least he did have that honor of not taking risking the blood of someone else for his own personal attainment of something. So let's proceed here. In pre-revolution England, bills of attainder were issued by a king whose authority had been limited by the Magna Charta. The king could no longer shout, "Off with his head," and expect the executioner to act. Instead, he would cause Parliament to issue a law removing the head of a political enemy, or he would ask Parliament to pass laws applying pain or penalty upon a described individual or group of people. A law with bite. A bite that applies to a defined person or group. A law issued and implemented by a single imperial power, like a policeman with power to convict, is a bill of attainder. They worked in Old England, but not on our soil. When the average person rubs shoulders with government, he is seldom in contact with a person from the legislative, executive, or judicial branches. Instead, he deals with day-to-day bureaucrats, officials charged with applying and enforcing administrative law. The agency impacting the greatest number of lives is the Internal Revenue Service. If a tax auditor is asked to justify his reasons for contacting you, he will cite a section of the Internal Revenue Code or one of the many regulations stemming from that administrative law. Are such laws bills of attainder? Society has long accepted such laws as appropriate, but were they authorized by the U.S. Constitution? That's something to think about. Are bills of attainder like administrative laws? If it walks like a duck, is it a duck? What is a bill of attainder? A bill is a law. To attain means to get. A bill of attainder is 1. An act of a legislature that 2. Identifies members of a group targeted by the law, and 3. Dictates a penalty to be inflicted 4. Without trial, outside the reach of a jury. So, that's a bill of attainder. Act of legislature that identifies members of a group targeted by the law and dictates a penalty to be inflicted without a trial outside the reach of a jury. So, a bill of attainder is a law designed to get something. Bills of attainder in English history were acts that removed the head of an enemy of the king without trial. The complete definition of this kind of law includes pains and penalties. The U.S. Constitution outlaws bills of attainder, laws designed to get or take life or property from people. Bills of attainder in England were judicial acts under the authority of the legislature. This shortcutting of due process, this punishment without interaction with a jury, without reference to the judiciary, is the key reason our founding fathers outlawed this practice. They disdained the idea that a single branch of government acting alone could put someone at risk. Compare this with the practice of regulators who apply fees, penalties, fines, and taxes without being subject to a jury, and you will understand how far we have strayed from the intent of the founders. Nobody would argue that when we receive a service, we should pay for that service. If you choose to drive on a toll road, you expect to stop at the booth and pay. If you use water provided by a local government agency, you will gladly chip in to help with the expenses involved in bringing that water to you. Beyond the costs we gladly pay, though, there are pains and penalties extracted by administrative laws that have morphed into a pattern of bureaucratic oppression. So attainder, as defined here, is to get or to take. Man, this thing ain't working today, is it? I wonder why. Give me 1 second here. See if I could do so. You know what I'm going to have to do is probably just refresh a bit here. Okay. Defined attainder. So it's to get something. It's to get or to take, to attain. All right. Let's proceed. What are those laws, codes, and regulations that give life to the bureaucracy? They are administrative laws, rules that regulate us. Are they different from the bills of attainder? An administrative law is 1. An act of a legislature or city or county government that 2. Identifies the members of a group, and 3. Potentially penalizes them 4. Without first asking a jury to determine whether the demand is appropriate. Isn't that what a bill of attainder is? Right? An act of legislator or city or county government that identifies the members of a group and potentially penalizes them without first asking a jury to determine whether the demand is appropriate. Yeah, it sounds a lot like the bill of attainder up here, which is an act of legislature that identifies members of a group targeted by the law, dictates a penalty to be inflicted without trial outside the reach of a jury. Sounds pretty similar to me. Does this mean that administrative laws, like income taxes, like tax laws, are out? All right, let me reread this. Does this mean that administrative laws, like income tax laws, are outlawed by the U.S. Constitution? If not, what did the founders outlaw when they prohibited bills of attainder? Now that's a good question. If so, how has administrative law become an accepted practice in violation of the Constitution? This is our central question. How has it become an accepted practice in violation of the Constitution? Now, I don't want to skip over this too soon. I want us to think about this because this is the question we have to answer when we leave here tonight. How has administrative law become an accepted practice in violation of the Constitution? Let's continue. Our Constitution gives Congress the right to regulate interstate commerce, that's commerce between the states. How is regulation of commerce possible if Congress cannot enforce regulation by passing laws that resemble bills of attainder? In the United States, most administrative law is supervised by the executive branch of government, while some independent agencies operate under the control of Congress. Whatever the control scheme, can a jury be expected to approve all administrative actions? According to the U.S. Constitution, regulations are subject to review by juries, a process placing bricks in a wall of protection, saving ordinary people from government oppression. If no fully informed and empowered jury has heard your case, authorities must force you to volunteer to be punished. If you do not volunteer to pay a tax, fine, or penalty, the Constitution requires that a jury be involved in the enforcement and collection process. If there is no jury review, the law being enforced appears to have the earmarks of a forbidden bill of attainder. Such laws may not be constitutional, but they are effective. Here is the answer. If the public is fooled into yielding to them. Did we get that? So, yeah. Yeah, we get a lot of civil bureaucracies with no checks and balances. And why? Well, that's another thing to put on the checklist there. Why are there no checks and balances? And who's responsible for checking and balancing these people, right? Aside from them checking and balancing themselves, who's checking and balancing their oppression of the people in violations of the Constitution? They don't. The other bodies, the three bodies, don't check themselves on that. They check themselves on powers that might be overlapping the other bodies. They're very protective of their own powers. But how about when any of them violate the Constitution against the people? Who stands up for the people at that point if we don't stand up for ourselves? All right, let's continue here. Has your city council, 1, established an ordinance that, 2, would specify a punishment, 3, applying to property owners who might build sheds in their backyards without first paying for a permit? Does this law allow administrative officials to punish you even though they do not first take you before a jury? If so, that city ordinance looks like a bill of attainder. Apply for the permit if you wish, but it cannot be forced upon you if the Constitution means anything. But you will more likely obey because you fear king government. The jury was designed to be a wall to protect individual liberty. What happened to that wall? We are proud that our nation's founders broke from traditional government by a king dictator and chose instead a form of government established, as Lincoln observed in his Gettysburg Address, of the people, by the people, and for the people. The Constitution sets up a people group wall of protection called the jury. Have the years eroded away that protection guaranteed by the U.S. Constitution? The founder did not want to trade King George for King Congress. The founders disdained tyranny. They wanted the people living in their new nation protected from unfair actions by both a personal tyrant and group tyrants. Individual people were to be guaranteed justice, that justice was to be applied by the people upon the people without the wave of any wand of punishment from a source other than the people. The founders gave juries of the people that task. The judicial branch of government was given responsibility to act only within the limits of due process applied to everybody accused of a crime. Those due process courts are to look to the authority of the jury to judge guilt or innocence. Let's see what's going on here. Come on. All right, there we go. Can't win with this thing here. I'm trying to get this chat moving here. All right, I think I got it going. All right, here we go. The people group was to be in charge. Government officials were to serve those in charge groups, people groups of voters and jurors, not to be served by them. Did the founders give us a thicker wall of protection than the court due process they put in place by those words in Article 1 of the Constitution? Does an imperial jury system guarantee even greater protection to the people? Yes, that guarantee is the prohibition against bills of attainder. Let's dig a little deeper here. So, do y'all follow me on this? Governments are supposed to serve those in charge people groups, not be served by the people groups. All right, let's dig a little deeper here. According to this Tech Law Journal Glossary Legal Attainder. All right, audit them. Here's your definition. A bill of attainder is a legislative act that singles out an individual or group for punishment without a trial. The Bill of Attainder clause was intended as an implementation of the separation of powers, a general safeguard against legislative exercise of the judicial function, or more simply, trial by legislature. That's U.S. versus Brown, 381, whatever, 1965. Capable legal researcher John Rowland writes in his treatise, Public Safety, or Bills of Attainder. Public Safety. To establish what a Bill of Attainder really is requires some research and reflection. Thomas M. Saunders has summarized the definitions in the various sources and precedents. A Bill of Attainder is a law or legal device used to outlaw people, suspend their civil rights, confiscate their property, put them to death, or otherwise punish them without a trial. William H. Rehnquist wrote, "Such actions were regarded as odious by the framers of the Constitution because it was the traditional role of a court, judging an individual case, to impose punishment." The Supreme Court, page 166. James Madison seemed to link employees of government to the concept of bills of attainder when he wrote, "Bills of attainder, ex post facto laws, and laws impairing the obligations of contracts are contrary to the first principles of the social compact and to every principle of sound legislature. The sober people of America are weary of the fluctuating policy which has directed the public councils. They have seen with regret and indignation that sudden changes and legislative interferences, in cases affecting their personal rights, becomes jobs in the hands of enterprising and influential speculators, ensnares the more industrious and less informed part of the community." Emphasis mine. James Madison, that's the Federalist Papers number 44, 1788. So ex post facto laws after the fact, right? When they cite you for something, but the law comes after you did the act, those are supposed to all be contrary to the first principles of the social compact. All right, let's continue here. All right. Professor offers evidence. Matthew Manweller, an instructor of political science at the University of Oregon, Eugene, has made available on the internet a paper entitled, "Can a reparations package be a bill of attainder?" In the paper, he defines bills of attainder in detail, using his findings to argue that a congressional act to pay money damages to any specific group is, in fact, a bill of attainder upon all who pay taxes. His thread of logic presents an argument that justifies viewing the federal income tax laws and other punitive administrative laws as bills of attainder. If federal income tax laws are not a collection of bills of attainder, you then must find those laws. 1. Are not put in place by legislative action. 2. Providing for no penalty or punishment. And 3. Applying no named person or group. The answer is obvious. Manweller explains that the courts have established a test for future attainder cases. In United States versus Lovett, 1946, later confirms in U.S. versus Brown, cited above. The court determined that a bill of attainder is 1. An act of legislature, 2. Inflicting punishment, and 3. Applying to named individuals or easily ascertainable groups who, 4. Have not been first brought to trial. Sounds pretty clear. Are these arguments making sense to anyone out there, or is this kind of, are we just swinging at windmills here, as they would say? I'm going to continue here. I'm assuming we're still transmitting here in the YouTube universe. You guys can just hit something in the chat or something, let me know everything's still coming through. But it seems like it is here on this end, on the Stream Health side. I'm going to continue. All right, we got some people there. Hey, is that O'Shea? All right. Mr. O'Shea, welcome. Welcome to you, the world famous. This is the world famous Brian O'Shea here. So we are privileged to have amongst us. All right, let me continue here. Is it disloyal for us to expect government to obey the U.S. Constitution? Has Congress put in place, 1, codes and regulations that, 2, would cause you to be charged interest or to be fined if, 3, you are viewed as a member of the group called taxpayer without, 4, applying that tax to you after trial and jury verdict? If so, Congress violates the U.S. Constitution when it asks you to pay income tax. We might protest that we want to support the government. Perhaps you do not object to paying taxes. That is a noble attitude. However, is it noble for us to ignore government violations of the U.S. Constitution? Should we expect government to be subject to the U.S. Constitution, or do you prefer living in a nation ruled by men rather than by law? Or I'd rather say being ruled by fools rather than rules. Do we want government to operate within written law? Or do we prefer tyranny managed by the whim of men? We need to support government operating within constitutional limits. Manweller refines the definition by adding 3 more prongs. He explains that to determine whether a law is a bill of attainder, according to currently existing case law, one must determine 1, whether the challenged statute falls within the historical meaning of legislative punishment, 2, whether the statute, viewed in terms of the type and severity of burdens imposed, reasonably can be said to further non-punitive legislative purposes, and 3, whether the legislative record evinces a congressional intent to punish. That's from McMullen in, see here, District 2. All right. In summary, the 3 tests that must be applied are historical, functional, motivational. So 1, whether the challenged statute falls within the historical meaning of legislative punishment, bills of attainder, right? Legislative punishment's one of the elements. 2, and that'd be the historical. 2, whether the statute, viewed in terms of the type and severity of burdens imposed, reasonably can be said to further non-punitive legislative purposes, right? Meaning that the money is not being used for anything punitive. That's functional, right? So the functional terms that they're using it for their own revenue generating, not because you're making paying back something that you took. And 3, motivational. Let's see, for 3 is whether the legislative record evinces a congressional intent to punish. So there you go. Congressional intent to punish is your motivation for it, right? The intention. So the historical, the functional, and the intentional, the motivational. So this little paragraph here kind of gives you a good idea of how you can challenge these things in a very reasonable way without even having to bring up these case laws, because you're understanding the basic intention of our founders' Constitution. So let's continue. The historical test. Ask if a law takes away property, money, or perhaps inflicts other dread consequences sometimes sought by England's kings. If so, it passes a historical test. It may be a bill of attainder. Okay, check 1. Check 2, functional test. Citing Nixon versus Administrator of General Services, Manweller concludes that the functional test is passed even if the bill does not impose a historical punishment. One must ask, is its function designed to punish in other respects? Any congressman will confess that the income tax does not fund government except to relieve the federal government from paying unnecessary interest on the federal debt to those privately owned Federal Reserve banks. Senators and representatives will admit that the reason for continuing the income tax is to allow Congress to do social engineering. An official bulletin issued by the Internal Revenue Service criticized this practice. Issued by the U.S. Department of the Treasury September 26, 2006, a comprehensive strategy for reducing the tax gap. The document complains of provisions created to meet social policy goals. These targeted provisions, which themselves are growing increasingly complicated, divert IRS resources from basic compliance efforts. Congress keeps the income tax in force in order to tweak the economy at will, favoring some groups and punishing others, while irritating even the IRS in the process. Thus, the income tax passes the functional test. It punishes a defined group without first securing judgment by a jury, as do countless other administrative laws. Are those laws bills of attainder? Now we go to the motivational test. Manweller explains. We're all following along here. Man, my chat, I'll have to keep it open on the phone here because I keep losing it over there. We're all good? Cool. All right. I think we're all right now. One more chat. Okay. Yep, there we go. Looks good. All right. Manweller explains that this test has to do with whether a bill is regulatory or drawn in retribution. He explains that the Brown case cited above declares that if there is no regulatory purpose underlying an act, a punishment has been inflicted. That regulatory act must not bring with it the element of pains and penalties. Does income tax law fit all three descriptions? If so, is the law a forbidden bill of attainder? Thus, if a law, 1, is a law, 2, with a penalty attached, 3, to an individual or group, and if the law would, 1, take property or money, 2, punish or penalize to fulfill a non-governmental, perhaps social purpose, 3, without a regulatory function being fulfilled, that law is a bill of attainder, unless, 4, the issue addressed is first presented to a jury limited by due process, which none are. Some might argue, Manweller observes, that a tax imposed on all citizens of a state does not single out an easily ascertainable group, and because everyone pays the tax, they are no different from any social welfare program. Everyone pays taxes to support welfare programs, yet only a select group of citizens receives the benefits. Under this logic, if reparations packages are bills of attainder, then any selectively disbursed public group evinces a bill of attainder. Punishment defined. Punishment is defined at this document here as some pain or penalty warranted by law inflicted on a person for the commission of a crime or misdemeanor, or for the omission of the performance of an act required by law. The punishments are fines, forfeitures, suspension, or deprivation of some political or civil right. So there's your punishment. Can we be forced to pay income tax? Forced, I guess you could say in some ways, yes. But let's see what Manweller has to conclude. For Congress to extract any tax for past abuses becomes constitutionally suspect. He has a narrow focus. He believes it is unjust for a taxpayer today to be forced to pay for social crimes committed by the grandfathers of those taxpayers in the past. Yet his reasoning applies to us today. Why should any individual protected by the guarantees in the U.S. Constitution be obligated to endure the pain or suffer a punishment for failing to observe a law with no regulatory purpose aside from social engineering, a law not first put in place by a jury of his peers. What power does Congress have to inflict upon any of us the attainder contained in the income tax laws? To enforce his conviction, Manweller cites Fletcher versus Peck. The legislature is then prohibited from passing a law by which a man's estate, or any part of it, shall be seized for a crime which was not declared by some previous law to render him liable for punishment. Before I go on, I just want to be very clear here that this is not to be intended to be any kind of recommendations, legal, lawful, or for any kind of professional, personal, or any other endeavor regarding anything to do with taxes, laws, legal, or any other personal matters. This is just for educational, entertainment purposes, and don't do this at home. All right, let's continue. What were the founders trying to do for us when they outlawed bills of attainder? The writers of the U.S. Constitution were building a wall of protection between individuals and the government, seeking to empower the group that established the nation, we the people. Lincoln, if he had lived, might have seen it this way. Were there no bills of attainder, government would be of the people, voted into office by the people in elections, counted honestly by the people, controlled by grand jury oversight, for the people, bowing to trial juries that shield individuals from oppression. If this is what the founders intended, my question is, at what point did the people surrender this shield to administrative bureaucrats? When did the wall fall? Was the Constitution amended to remove Article 1, Section 9, Paragraph 3? Not in my copy. To the contrary, the prohibition is repeated to apply to all states in Article 1, Section 10, Paragraph 1. When did juries become more of a threat to the people group than a haven of protection? Legal experts will disagree. It is to expose those disagreements and consider each one with an open mind that I have written this paper. Please submit to me your disagreements or those arguments lacking. Join me in confronting any bureaucrat you meet, asking how that agency seeks authority over you through legislative action designed to punish you. Ask where you can find in any law or court case that bureaucratic behavior can be justified, that bills of attainder have become constitutional, that we, the people group, was not to manage government, but it was to watch over it and determine that no individual was oppressed by government or treated unfairly by any government officer or agent. Individuals were to be immune from injustice, with the immunity defined by ordinary people not employed within government. Those for the people, juries, were to provide a wall of separation between individuals and laws of Congress. Admittedly, that first Congress, charged both to regulate and not to apply pains and penalties, lived under a conundrum. How could they both expect regulations to be observed and not be required to present each issue to a jury? And to be required to present each issue to a jury. I have not researched those early years of congressional activity, so I do not know when the contradiction exposed in this paper developed. I am hoping my readers will enlighten me. No matter the instruction I receive, however, the contradiction remains. Administrative laws have the marks of bills of attainder. Do they violate the U.S. Constitution? We must try to solve this problem. Are congressional acts, state legislation, county and city ordinances constitutionally required to include jury review as part of the procedure mandated by administrative laws that regulate commerce? Does this make sense? The theory I present here makes sense to me. What does not make sense is that nobody writing on the subject of the U.S. Constitution and law has popularized this opinion. Of course, that means it is possible I have made a mistake in my research or in my reasoning. If so, I confess that my contact with reality is insufficient and that perhaps I belong in the loony bin. I cannot be faulted, though, for making public this writing for the purpose of finding my errors. I suspect it is our government that is out of touch with reality. Doesn't government have as much obligation to full disclosure as does a bank lender? Though all comers are welcome, especially if you are an attorney, you are cordially invited to set me straight, even an esquire, explaining where I am wrong. Here are my core questions. Is government out of tune with reality? Unable to read and abide by the Constitution? Or are capable readers of that document unrealistic for expecting government to display integrity? On the other hand, if I am not wrong, may we see a flood of objections to bureaucratic oppression and the filing of Title 42 complaints in federal court designed to rebuild that wall of protection, the authority of the jury. If you enter a court with the expectation that the judge intends to honor his oath to protect the Constitution as written, and if you challenge the judge to place his intent on the record, you might become amazed at how court procedure could work in your favor. Procedure means everything to a judge. Work into your argument the fact that any judge should be eager to follow the procedure demanded by the Constitution in outlawing bills of attainder, if that judge seeks to be faithful to the founding document. In the words reminding us of Patrick Henry, give me my constitutionally guaranteed liberty, or tell me why not. This is by Richard Palmquist. So, great article by a great man. I hope everybody learned a little bit of something from this, because I sure did. I believe everybody needs to consider these all these points, these elements of where it went wrong. When did it go wrong? When did we give up that wall of protection that we had? And how did this all get flipped around? And what can we do to set it straight again? And that's what the questions we should be thinking about every day when we're dealing with this question of, could administrative law be unconstitutional? I really appreciate everyone that showed up tonight for this. It's really been a really nice document. It was good to get the feedback from you guys. I certainly hope that we're all going to take a different approach now as we deal with our public official servants and elected governmental officials, to hold them to their obligation to honor their oath, protecting our Constitution, and not to abuse the people with the power that is entrusted with them. And it's up to the people to ensure that it's better than just the balances of the three branches of government to keep them honest, but it's also up to the people to keep our government in check and to not let them take away power so easily from us, or our wall of protection of juries. So Title 42 is the homework. Maybe it'll be the next subject. Other than that, Chosen, Island Walker, everybody that came, I appreciate you all for showing up. Audit Them. Everyone needs to subscribe to the Audit Them channel. Mr. O'Shea, world famous. Appreciate you here too. And everyone else that came. I'm going to try and keep a few more live streams going again. And maybe we'll all be able to get more of a groundswell going again with learning these things. Heard they were going to try to start taxing our assets federally too, you down at baseball card collections. Well, again, they're getting away with so much. Wouldn't you think they would expand it? So we're either going to be complying with insanity or wake up to it and ask those questions. When did it all go wrong? Where did it all go wrong? And what are we going to do to fix it? Because at this point, the founders would be rolling in their graves if they saw us just bending over backwards for this nonsense. So, on that note, I really enjoy doing this with everybody that came tonight. I appreciate you all for spending your time here, knowing there's so much more out there on the YouTube universe for you to choose to spend your time. But by learning this is something that's going to be a benefit to all of us living here in this land, because these are some of the things that were given to us that previous generations, hundreds of years ago, thousands of years ago, didn't even conceive of. And for us to squander it away so easily would just be a travesty. So again, salute to everybody that came. Let's put this knowledge into action, and let's keep the dream alive. On that, I thank you all for coming, and I'll see you on the next one. Peace out.